Mr. Estrada Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
No. Anyone promised you anything other than the plea?
No.
No. Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
No. Counsel, did you advise the defendant on his immigration status and the impact this plea would have upon him?
Yes, Your Honor, and he did have an interview for about the letter they recommended. Of course, it's something about less than being covered, but because it's certain.
CR 2763E, State of Texas versus Lazaro Alfonso Estrada Perez. Can our parties announce for the record for the state?
R2763E. There is something I wanted to bring up about discovery though, but if we can do that whenever that comes up.
All right. Are you Mr. Estrada Perez?
Yes.
All right. Okay, off the record for a moment. All right, everyone, do not approach the coordinator when I'm on the record. Everyone, this is the last case I'm calling before lunch. So everybody else, we've been here since 9. You'll need to be back at 1:30, the end. All right, we're back on the record. Are you Mr. Estrada Perez?
Yes.
Are you the interpreter?
Yes, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Norma Nero.
Mr. Estrada Perez, all of the documents that I'm going to review with you, they are in English. For those documents, review with you in Spanish.
Yes.
And counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
I do, Your Honor.
And have you been able to communicate with your client in Spanish?
I have, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
We believe we have, Your Honor, and I have looked it over as much as I can.
All right, and state.
Judge, so the reason why I wanted to bring this up is that there were 2 discovery acknowledgements filed in this case. One of them for this case number, but then another one filed for the accompanying case number. My understanding is that on Verific and e-discovery, it shows up all the discovery on the other case, but it's the companion one to this one. So I'm just making sure the defense had access to that other one. I remember dropped off the hard drive and I gave him a copy of everything.
We have, Your Honor, and we did look at everything.
All right, the court will find that the state is in compliance with discovery. Mr. Estrada Perez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1, waiving count 2.
Any objection?
None at all.
Mr. Estrada Perez, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense in count 1 of aggravated kidnapping? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Estrada Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, did you advise the defendant on his immigration status and the impact this plea would have upon him?
Yes, Your Honor, and he did have an interview for a Padilla letter, and they recommended, of course, that something a lot less than being offered, but because it is serious felony. And knowing all that, he's in mission to follow the agreement.
Mr. Estrada Perez, did you have a chance to speak with an immigration attorney concerning the impact this plea would have on your immigration status?
Yes.
Do you remember that attorney's name?
No, I don't remember.
This is made to- It was from the public defender, so yes, it was Miss May, Sarah.
All right. Did she advise you of the consequences of pleading no contest or guilty and the impact it will have on your immigration status?
Yes.
Did that advice include possible consequences such as deportation, the denial of naturalization, or re-entry into the United States?
Yes.
And do you understand the impact this plea will have on your immigration status?
Yes.
And knowing the impact this case will have on your immigration status, do you still wish to go forward with the plea?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial.
As the hearing moves forward, the tension in the room becomes more noticeable when the defendant is personally addressed and made fully aware of the seriousness of his decision. He is reminded in clear and firm language that this is not just a routine step, but a life-altering moment that will shape his future for years to come. The consequences of his plea are explained in depth, emphasizing that accepting it means giving up certain rights and facing a significant prison sentence. Particular focus is placed on how this decision extends beyond incarceration, especially due to his non-citizen status, which could result in forced removal and permanent separation from the life he has built. Even after being given multiple opportunities to pause, reconsider, or seek further clarification, the defendant remains steady and chooses to proceed. His demeanor reflects a mix of understanding and resignation, as he accepts the reality of the situation and the irreversible nature of the path he is choosing, marking a pivotal turning point in the proceeding.
Did you review the plea bargain page with your attorney and did you understand it?
Yes.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at 10 years in the prison. There are no applications. They're taking in consideration 2023 CR 2764E. Did you also understand that if the court find that there was a deadly weapon involved, the court will find a deadly weapon finding?
Yes.
Did you understand that to be the entirety of your plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Defense, is that the plea?
It is.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to count one, paragraph A and B, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State all proceeds to exhibit what are all attachments.
We have chance to review, Your Honor, no objections.
Thank you. Mr. Perez, did you have a chance to review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits. After reviewing state's exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We would ask that you follow the plea bargaining agreement made with the state, Your Honor, and impose a 10-year sentence.
All right, anything you wish to say, Mr. Estrada Perez?
No.
All right, the court will find you guilty. The court is going to sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. Take in consideration 2023 CR 2764E. Is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, and I'm also going to put in the judgment, no illegal re-entry into the United States. All right, if you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Mr. Estrada Perez, in this world, you have to learn one thing. And that one thing you need to learn is you cannot build your happiness on somebody else's misery. Do you understand?
Yes.
All right, good luck to you.
No, we excuse, Your Honor.
You're excused. All right, Norma, these are the people who are coming back at 1:30.
Maybe excuse your.
Yes, thank you so much.
As the session reaches its final moments, a deep sense of finality settles over the room as the decision is delivered with firm clarity and authority. The defendant stands in silence, fully confronted with the reality of what has just unfolded, understanding that this is not just the end of a proceeding, but the beginning of a long and life-altering chapter. Every word reinforces that the consequences are serious, lasting, and unavoidable, extending far beyond the years to be spent behind bars. The imposed restrictions make it clear that even after serving the sentence, the impact of this moment will continue to shape his future, limiting opportunities and altering the course of his life permanently. In these closing moments, the tone shifts slightly to something more reflective yet still stern, as a powerful message is delivered about personal responsibility and the weight of one's choices. It serves as a reminder that decisions made in a matter of moments can carry consequences that last a lifetime. The defendant's quiet demeanor reflects a mix of realization and resignation, as there is nothing left to argue or change. The atmosphere remains heavy, filled with a sense of closure and gravity, as everything comes to an end. What lingers is not just the sentence itself, but the undeniable lesson it leaves behind, a stark reminder of how actions can define a person's path and how quickly life can take a drastic turn.